Good morning, afternoon, evening, next day, before. Hello, everybody. Not legal advice. Please like, subscribe, share, comment, whatever else applies. Obviously, this is opinion. Don't rely upon anything I say, as I always say. Hopefully, if you can't hear me, then do a somersault so I could see it in the comments. Hopefully, you guys can hear this. If you can't hear it, indicate so, and I will change accordingly. It only took me like 45 minutes the last time to make that correction. So great. Looks like you guys can hear me. Wonderful, wonderful, wonderful. So today I was going to talk about three things in this order: Tesla and the court hearing that they just had, MMTLP and an experience I had. Thank you, by the way, about the sound. And last but not least, GTII, and I'm going to do it in that order. But of course, before we get to that stuff, I wanted to talk about, do you know what kind of car dogs prefer to drive? Of course, Ferrari. How did the dog travel from Boston to New York? He took a Greyhound. And last but not least, what do dogs get after they graduate from obedience school? They're masters, of course. All right, so let's, in order as I described it, Tesla. So Tesla, thank you very much. Tesla had a hearing on Friday, last Friday, and it was regard to the issue of ratification. So if you're not following the Tesla litigation, the court in Delaware threw out the pay package for Elon Musk that had been issued for the period of 2018 through 2023. And the only thing that remained was the attorney's fees. So there was a hearing regarding the attorney's fees. However, there was a change in circumstances. A new pay package was actually the old pay package that had been thrown out by the court in Delaware was ratified, and the attorneys for Tesla and related sought to have that ratification enforced so it would, in essence, vacate the judgment against Elon. There was a hearing on Friday, and even though I wasn't there, although I was there in a way, whatever way that is, but I wasn't there, and there's no transcript. I haven't seen a transcript, but I saw enough discussion about it, and clearly it seemed to me that the Judge McCormick, who doesn't particularly seem to be a fan of Tesla or Elon to this point in time, seemed concerned about the ability to do a ratification of something that had been found to be a breach of fiduciary duty. Now, that's been her take all along, in my view. And in a May 28th letter, it seemed to come up. And it may be the fact she rules differently. It may be the fact that she rules that ratification's not before her properly. But at this point in time, I don't think she's, just my view, and for whatever that's worth, I don't think she's going to approve the ratification, and then she would leave it up to the Delaware Supreme Court to deal with that issue. And the attorney's fee issue is still pending because there's a Delaware Supreme Court case dealing with attorney's fees, and it may be that she's not going to issue a ruling on the ratification and the attorney's fees until the Delaware Supreme Court rules on the attorney's fees. That will probably be sometime this year, but I don't know for sure. They're not super fast. But that's where Tesla stands. There was a hearing on Friday. Both sides presented their arguments. There wasn't as much testimony, it didn't appear to be, as there was in the attorney's fee hearing. And again, in my opinion, and we'll see how it turns out, the court was somewhat skeptical of applying the ratification post a purported breach of fiduciary duty, but we shall see. And again, it's going to be appealed to the Delaware Supreme Court in some fashion, either the attorney's fee issue or ratification. So it's not over, but it's interesting to see. It'll be interesting to see where it goes. Obviously, Tesla has moved their headquarters to Texas, and it'll be interesting to see if there'll be litigation involving which state has the right to litigate future actions. I wouldn't be surprised if that's not a contested issue in the future. And it might even concern Elon's current pay package in some fashion. So we'll have to see how that plays out. Okay, so that's Tesla. That brings you up to date. And again, we're waiting the ruling on the issue of attorney's fees, which was requested in the billions, and the issue of ratification, whether shareholders were able to reinstall basically Elon's pay package, which was a grant of options of Tesla shares. That's one. Two, let's go to MMTLP. To any of you out there who don't know MMTLP, that's obviously the stock with 65,000 shareholders who unceremoniously, including myself, suffered a U3 halt. Never knew what a U3 halt was before that. And some almost were going on 2 years. I think it's over 600 days at this point in time. No closing, transactions not closed, no settlement of the stock. And there is still some litigation that's ongoing, and we'll see where that goes. There's some action that's been contemplated or attempted in Congress, and we'll see where that goes. Some people are waiting for NextBridge, the company that succeeded MMTLP, and how they will act. And I know they've acted in the past. I don't know what specifically they are doing because I've never spoken to Greg McCabe, for example. But some people believe they're acting that way. And my angle, at least my attempt, was through arbitration, and also to show that the arbitration system that all consumer shareholders are bound to use is entirely unfair. I kind of did a bunch of videos going through my arbitration history in this case, and then I went through the litigation involving other parties and trying to get FINRA and Fidelity to take responsibility for what's going on. And I went through the arbitration process involving FINRA, and I clamored and complained about my arbiter and about the process. If you recall, I sought discovery, and whatever I asked for, everything, not even like a bathroom break was granted, but everything was denied, and denied without a hearing and without any reasoning. Now, I found that somewhat suspicious in my mind, and also unfair. And after the fact, when I determined that the arbiters weren't getting paid for those hearings, it made more sense to me if, in fact, those arbiters didn't spend a whole bunch of time reviewing motions, etc., that they weren't being paid on. So after going through proceedings, and after the proceedings being entirely one-sided, and being concerned about getting a positive result that was negative, in other words, getting a result where if the arbiter himself, the lead arbiter, there was 3 arbiters, one who controlled proceedings, if that arbiter who I happened to sue, who I tried to get rid of multiple times, was smart, they could rule in my favor, but lock in an extremely low price. And that's what I was concerned of. I was concerned of the arbiter having some level of vindictiveness. And I didn't want to bind everybody to that. So right before we were going to trial, the action was dismissed. Now, and I've complained about the arbitration, and then Curtis, some of you know Curtis, came out and he found a bunch of people involved in the committee who may have been involved in U3 halt, might have been in Fidelity also. So I thought about that and how I might use it. Then about a week ago, an attorney called me up who had seen one of my filings, and she's involved in arbitration with the same arbiter, 3-judge panel, with the same arbiter being the central arbiter, but she's not at trial yet or hasn't got a result yet. So she's behind me, let's say, in status of the proceedings. And she asked me about my experience with the arbiter. And before I spoke, she told me about her experience, and she complained about the arbiter and for various reasons. Nothing that jumps out at me at this point in time. But she also wondered and out loud whether the arbiter had an allegiance to the capital markets, like, for example, I don't think she said this, but it might be like Fidelity, that she'd have a lot more, the arbiter would have a lot more cases with Fidelity than Joe Blow, and their allegiance might be aligned to Fidelity. She said that, and I've been saying that for months and now years at this point in time. But then she said that something really interesting about the time that I dismissed my arbitration because of where it was going, and I'd asked for the arbiter to be kicked out multiple times, which resulted in me suing him. She said, in a case where he was the lead arbiter, a result came in, and the losing party, which was the non-broker, for example, sought to vacate the award because they said that in effect, the arbiter was incompetent, not following the law, etc. Very much mirroring what I have said throughout my arbitration. There was a hearing, and again, I haven't seen the paperwork, nor have I seen the transcript. I just heard a story from the attorney. So I don't know if it's 100% accurate, but this is what I was told. After the court read the papers and had a hearing, they indicated they were inclined to grant the motion to vacate on the basis that the arbiters didn't really know what they were doing. That's my language. Weren't following the law, etc., which I thought very striking. Before the court entered that order, the capital company, whether that be FINRA or a broker, they agreed to vacate the order, that being the final order of the arbitration. They vacated that order without the judge granting the motion to vacate. So the losing party filed a motion to vacate. At the hearing, and based on the papers, the judge said he was inclined to grant that motion. Before the judge granted the motion, FINRA or the broker agreed to vacate the award so it wouldn't show up as the judge throwing out the arbitration award and criticizing the lead arbiter, who happened to be the same arbiter. Then I looked back in the disclosures. In this January, it discloses a motion to vacate, but doesn't disclose any of what I just told you about the judge basically saying, this doesn't make any sense, and was going to throw out the award. And this attorney who contacted me, she is now in the same position where either she's done the proceeding or she's considering to attack an award. And we're now kind of in communication. I'm going to be providing her some of my motions I filed to get rid of the arbiter, which I did multiple times without any kind of real reply. And I'm going to get from her, hopefully, more detail as to that case where the judge was going to vacate the award of the arbiter because of either incompetency or lack of ability to apply the law. One way or the other, I'm going to contact FINRA, and I'm going to make a demand that they vacate my dismissal and terminate the arbiter, and then we'll see where it goes from there. That's on MMTLP. When I find out more information about the arbiter and how FINRA, what FINRA knew when they knew, just another example, FINRA's providing and guiding and monitoring arbitrations, but how closely and how competently are their arbiters? I mean, I don't know. I mean, that's the question. And the call from an attorney out of the blue with the same arbiter referencing a third case where there was another issue really causes concern. And so I will follow it up to FINRA, and we'll see where it goes. Obviously, I'll keep you apprised. That's MMTLP. And last but not least is GTII. And GTII currently, as of today, as we speak, Sunday morning, 10 o'clock Pacific time, there's a hearing set on Wednesday morning in Las Vegas for a TRO and for appointment, order to show cause regarding the appointment of a receiver, TRO with regard to certain actions that the locals should not be able to do. It's both, and a bunch of requests, and we'll see what the judge orders. The application was submitted sometime back. Originally, the complaint, sorry about that. Originally, the complaint was filed June 27th through some maneuvers and an attempt to shift it to federal court, and then back to state court. And then the state court judge, who's the third judge, was out of town and had a couple of trials. So that's the earliest date. And I think the court explained it to counsel, our counsel in this case, explained it why it worked that way. But anyway, there was a motion filed to get a receiver in, and the request is based in the fact that not current with their filings, that the downlisting, and there's a downlisting, and now nobody has access to trade it in essence. And I'm going to address that in a second. And that somebody should go in to try to address those problems. Now, what is interesting is it's now traded in the expert market. And note, now you got to think of the big picture. Now we're talking about GTII. It got downlisted before. So in April, I think it's April 11th of 2023, because of reoccurring problems with regard to disclosures, with regard to insider transactions and or beneficial ownership, it was downlisted from the second level of OTC to the pink sheets. That's a negative move. It may impact your ability to get access to certain capital markets. The reason why, and that wasn't disclosed, by the way, the facts have never been disclosed by anybody at GTII, at least to us, as to why that happened specifically. What were the underlying facts regarding the insider transactions and issues regarding beneficial ownership, and why has that not been rectified? And we know that Mr. Abari has been on the scene as a consultant since December, been COO apparently since April based upon a recent filing, but nothing's changed. And because of that, when they didn't do their 10Q filing, they got downlisted again, not this time from second level to pink sheets, but from pink sheets to the expert market. Expert market is very limited, not transparent. I don't think we have access. I'm not an expert in the expert market. I don't think we have access to the expert market unless you're a broker or an accredited investor or perhaps somebody else. But the quotations are not visible. So it's not a positive. And theoretically, if they hadn't been downlisted back in April and or corrected that issue, then we wouldn't have been placed in the expert market now. Now, I'm speculating some, but it makes sense. If you got dropped a level and then you got dropped a level again, if you hadn't been dropped the first time, then maybe you wouldn't be in the expert market. If we weren't in the expert market, then everybody could trade the security. And if you recall, and this is interesting, it's just the history, and then I'll talk more about the hearing. But remember, Mr. Abari was brought in December of 2023 as a consultant to, I think, help the board. And one of the things he was tasked with were retirement succession plan. And I think that's referenced in an April 9th PR also. That's one of the things he was tasked with. And it's also referenced in that April 9 PR referencing his hiring effective May 1, that one of the things he was hired to do was to help stay compliant with filings, because that's an essential quality of GTII. They're making themselves, they're an incubator. So they're giving basically a clean operation to somebody coming in. So one of their mission statements is to keep compliant. So in the April 9th PR reflecting his hiring as COO, it references the mission statement and staying compliant with their filings, amongst other things. So two things that struck me is there's reference to the succession plan back in December, and there's reference to the compliance in April. Now we know in April there was a problem because they promised delivery of their financial that dealt with issues that I don't think they dealt with, just in my opinion. But they promised that as of 3/31. On 4/1, they delivered a note saying it's going to be late. On 4/16, they delivered the 10K, which had a lot of information that was concerning. Let's just say that, at least concerning to me, if nothing else. But that was after that PR from GTII saying that Rabari was joining. So it's interesting that order, the 10K, came after the PR. And if you recall, even though that PR says Rabari would start COO effective May 1, the July 2nd filing, I think there was a PR July 16th, said that the effective date of his starting as COO was April 1. Now I'm referring to Rabari. So pretty confusing. We have two different dates. Hard to tell why is that done. Remember, there's an indemnity agreement that seemingly protects Rabari, at least as a document that I saw in their filings. But what's interesting is in that April 9th PR, again, compliance with filings was deemed an essential part of the mission statement of GTII. And Rabari was around along with the other other officers and management, and whether Rabari was actually a officer or just a consultant at that time, because on one hand it says May 1, on one hand it says April 1. He was intimately involved, and certainly in the future was going to be involved because he was named COO and now CEO. Although we don't know if he's taken over for CEO because that required a board vote, and there were some other conditions, I believe, to his starting as CEO. I've not seen a board vote, and I haven't seen a PR saying that he has started as CEO, and I don't know because of the proceedings that have arisen whether that has changed, whether he started or not started as the CEO. But so one thing is the compliance, and if he was brought in to keep compliant and we're not in compliance, then that's a problem, I would say. And maybe they're going to argue that their auditor that they chose, and remember, Mr. Reichman ran a tax and business practice, previously was an American Express at some high position, and was the CEO's chief financial officer and chief accounting officer. To the extent there were problems with their auditor, why didn't the person with all those titles not know what's going on? And if they didn't, isn't that a problem? And if someone was there today, shouldn't they be gone? And shouldn't they pursue relief if there was a problem, especially if there was a problem with the auditor? If the supervisor of the auditor didn't do a good job and shareholders were harmed, then I think that's got to be investigated. And we know management reserved their rights against the auditor, and specifically in some of their PRs, they say, if we reserve the right to go after our fees and damages if it turns out there's nonsense going on with the auditing process. Wouldn't that also apply to the supervisor of the auditing? Anyway, so we have the issue of the auditor, but the auditor being intimately involved, seemingly, or at least having people at GTII that would seemingly be closely supervising, or should be closely supervising, an auditor and with expertise. And then we have the succession plan. So in that July 16th, I think it's July 16th PR that relates to the July 2nd announcement of Mr. Rabari becoming the CEO August 1 based on certain conditions, and backdating, I'm calling it a backdating the CEO position from May 1 to April 1. Recall that in December, it was referenced, or in the December period, it was referenced that he was brought in to deal with the retirement and succession plan. And in the July 16th, so that's like 7-8 months later, guess what's in that PR? It says he's here to help with the succession plan. So what happened? I mean, what efforts and what was accomplished with regard to the retirement and succession plan, other than it's seemingly Mr. Abari now being much more personally involved in GTII. But other than that, what happened? And why does he have to be involved in that again if he was brought in to do it in the first place? Just confusing. And recall, I sent these gentlemen dozens of emails asking them questions, requesting their input, and as of today still have gotten no response, zero. And again, if someone asks you a question and it might be a tough question and you choose not to respond and you don't take the fifth, it's not like you're evading criminal conduct or anything like that. Because I've been involved in cases before where one of the parties or a defendant had to take the fifth, literally, in a case, but that's not the case here. Nobody's taken the fifth or anything like that, just not responded. So management not responding to shareholders is not a good thing. Management not responding to claims about how they manage the business, at least not explaining things, is suggestive that they are avoiding something because there might be truth to the question. And to this point in time, nobody's responded to anything. So again, getting back to the interesting thing about the timing of Rabari and whether it's May 1st or April 1st, and the succession plan again, and what happened to the compliance and the mission statement, we're all that, and trying to blame the prior auditor, but having the CEO, CFO, chief accounting officer, former tax expert be with the company and seemingly have an obligation to supervise. I have a lot of questions. I do have a lot of questions. I mean, it's a lot of questions. And I don't know what of those questions will come up at the hearing on Wednesday, or what of those questions will come up. It's interesting because the hearing on Wednesday relates to the lawsuit they filed against me. If you recall, they filed an action for defamation against me. And I haven't yet responded because I have theoretically to September 10th to respond. And perhaps what's going to occur over the next couple of weeks in Vegas in that action might have an impact upon my case. Isn't it beautiful outside, by the way? Look at the weather outside. Those beautiful puffy clouds, those trees, very steady, not a breeze. If you notice, zero breeze again. I'm sorry about that. Pretty hot outside. But I don't know what they're going to claim. But it's interesting the connection between the auditor and the expertise of the CEO. And I don't know what Mr. Rabari has done to date in terms of advancing a cause. I know in like the July 2nd filing, there was some reference in there of potential parties they were going to try and engage with. But it would be like me saying, let's say for the sake of discussion, GTII was an incubator that looked for companies to bring in to roll revenue in to the company. And let's say they would make deals with companies. So, maybe they'd like to have McDonald's as their as a potential suitor, but that's about as far along it sounds like they are with the ones they mentioned. They certainly didn't provide any detail. Nobody's reached out to anybody at any point in time that I've been aware of since I've been involved. Now, to add on top of that, we have the Alpine background, and we have the apparent concentrated short position at one point in time. And I continue to look at the status of the appeal in DC, and that's still pending. And the action in Arizona is also still pending. So nothing has gone on, or maybe it has gone on, but no ruling, let's say. And I'm waiting to see that. Now, I don't believe, and I don't put in my own view, this is just me, because again, this is all opinion. I don't focus on any type of short squeeze or the possibility of that. I don't know if one's going to occur. I don't think you can predict when and where and if. But my view on GTII was to bring in some business And if you bring in business and revenue, that would facilitate the movement of the stock. That's my personal belief. Don't take that as any advice, since I don't know diddly squat about anything. But that's my view. I thought if the business became successful, then the stock would become successful. That was my view, not financial advice, of course. And that's why when everybody was trying to reach out, or when several people reached out and said they had reached out and were not able to consummate a deal, that would concern me. And then if you look at the financials, they reference transactions, but not completed transactions. And we know in 2022, 2023, and probably 2024 to date, no revenue. So what's happening there in terms of acquisitions? It doesn't seem like there's a lot going on there, or not a lot consummated. And why not? What's the reason? And why not disclose the reason if, in fact, there's a good reason? I don't know what the reason is. Can't be at all bad deals. And, if it's all bad deals, then why did you get into your DD on those? Why did you spend your time on a bunch of bad deals? Either they're good deals and for some reason you'd not be able to consummate them, or they're bad deals. And my question would be why you didn't know they were bad deals, and why did you waste your time and money and efforts on those? I don't know which one applies. Please let me know. Again, with all the other questions that you have not responded to, please let me know. So hearings on Wednesday, I'm going to obviously be there and participate to the extent I can participate. I will be at the counsel table, I believe. I'm not counsel, but I will be at the counsel table representing all the plaintiffs and all the shareholders. And that's unless something happens and the hearing doesn't go on Wednesday. Now, as of now, the GTII crew has not filed an opposition, or nobody has presented me with an opposition. Wouldn't be to me, it would be to counsel in Nevada. But counsel in Nevada would present it to me if they receive it, because they would ask me for my feedback, because that's how we've kind of operated to this point in time. I gave them some feedback last week, and I don't know if GTII crew will be filing a brief. I'd be surprised if they didn't. They may be waiting closer in time to the hearing so that plaintiff, being us, won't be able to respond to it in writing before the hearing. You never know. Does GTI have a chance? I mean, you never know. It's court, so court is always undefined. To me, factually, it should be a slam dunk, factually. But, courts might have different concerns, and I've been surprised in court before. And that's why no lawyer will give you I'm responding to a question, by the way. So it's M. Casey's question. So I'm going to put it up there. So I haven't even dealt with that. That's a great question. So I've been just babbling about other stuff. So thank you, M. Casey, for getting me to answer a legitimate question. So in any court hearing, you don't know what the judge is thinking. Is the judge, seemingly this judge is open to the relief that we're requesting, the receiver and the TRO. So they're not the type of judge that would be opposed to it as a rule. And there's a lot of facts, obviously, in the moving papers, we talked about it. There's issues in regard to the distribution of shares. We know the masseuse and the mechanic. Again, it's got to be a movie, either a movie or a new show on Netflix, the masseuse and the mechanic. I think that's a winner, honestly. So we have the shares, we have the issue of we have the canceled shares. Remember, we had that happened in June. All of a sudden, 36 million shares inadvertently or erroneously issued that got canceled. What was that all about? We have all the shares in foundations and to insiders, perhaps family members, girlfriends. We have the huge losses, right, by reflected in their own financials. We know they picked a terrible auditor. We know they had to cancel the shares. We know they haven't done all their filings. We know they diluted the stock, at least based on their filings in 2022 to 2023, from something on the order of 260 million to 370 million shares, which is about 45%. That dilution happened too. We don't know why. We know that the cash position, as reflected in the 2023 financial as compared to 2022, seems to have changed negatively. We know in the complaint in Nevada that there's a claim in the complaint, and it's just a complaint, and it's just a claim. But we know in that complaint there's a contention that some acquisition was set up by an insider of the company, that stock was given as consideration, the stock was sold, and the money generated from the stock was split between the two principals involved in the transaction. I think one is claimed to be an officer or director, and one is claimed to be a counsel for the firm. And it suggested it wasn't a real acquisition. In other words, because there was no revenue generated. So what was that all about? There also might be, and I think the claim is in the Nevada claim, that in some of the documents that might have been signed, because they received shares, that their references or representations were not accurate in some of the documents. Not certain of the specifics of that at all, but that's another allegation. Of course, my own personal experience is I reached out to them numerous times. I did contact their counsel. He represented himself as counsel for GTII, both counsels, I think. Mr. Fattel, Mr. Markowitz, I think I spoke to both of them. I spoke to another attorney who had I guess, a relationship with them way back, and I spoke to him recently, or he contacted me recently also. So that went on. So all that's going on in the background. So with all that in the background and all the facts, and the fact now the stock itself is not tradable, really, for us, it's in the expert market and we're locked out, I think that's a compelling story to a court. But whether a judge agrees with that, I have no idea. But I think it's compelling. I think there's enough information in there to put in a independent party, whoever that is, to take over control and figure out what's going on. Figure out what's going on with the financial statements, because obviously they have to be audited. Figure out what's going on with the distribution of stock and the cash position, everything, because as of this point in time, it looks like a complete mess, we would say at best. So that's what's going to happen on Wednesday. There'll be a hearing on that. Whether the judge rules on Wednesday, or we'll have a ruling before Wednesday, or we'll have a ruling shortly after Wednesday, we will see. It really depends on the judge and their style. Obviously, it will be, we being the shareholders, we're going to encourage the court to act quickly in light of the inability of us to trade. And we don't know what the principals can or cannot do during this period of time. We don't know either way. And again, all opinion, just my speculation based upon what I see and what I speculate and opinionate upon. Now, so that's what's going to happen on Wednesday, and I'll report back. Hopefully Wednesday, I can report at some point in time and give you an update after the hearing. Probably wouldn't be till late afternoon on the 7th. That's the day of the hearing, if the hearing goes forward. It's a little bit of a tricky day for me. It's also my anniversary, and I'll be coming back from somewhere. So I will work it in somewhere and try to stay married that same day. Now, last but not least, I wanted to kind of pass on something, because we're in the expert market, and we all, maybe some of you have an idea how it operates, but I really didn't. And I have some people that occasionally reach out to me for various reasons that explain things. And I don't know if they're accurate, but somebody reached out to me, and he's reached out to me before, and he seems to be knowledgeable. I don't know if he's accurate, but he appears to be knowledgeable. And this time he was talking about the expert markets. And I thought some of it that he said was interesting. I don't know if it's accurate, so you have to do your own research, but I thought it was interesting. So he says, in the expert market, market makers love a stock like this because it's basically like the old type of stock of the 90s. They can't lose. Also, it's by and large unregulated. It's unsolicited orders only, and the market makers do not have to put up a legitimate bid asks. Now, we're referring to the expert market. And I don't know if that's true, but I'm just telling you what somebody sent to me. This is considered institutional-only trading. Thus, a market maker can show a bid of, say, 7 cents, and someone holding gets excited and enters a sale of 5,000 shares, but the market maker can execute at 2 cents. They can also take an order, sell it short, and use the buy order as a backfill. It's the Wild West, and the OTC doesn't care. So that's what he's indicated. So he indicates and again, it's somebody who in my discussions with him definitely has experience, but I can't vouch for the accuracy. But obviously, we all know we don't really have access to that market. And it's different than it was before it got placed in that market. Even when it was pink sheets, we all could trade it, at least to some degree. Even though it was a problem with dividend, we could all do something. So I found that interesting. I definitely feel uncomfortable myself in the expert market since I don't have access to it and we can't see the quotations. So anybody, just be aware of that if you're in the expert market, if you're going to transact in the expert market. And if you have a different opinion or experience, feel free to comment and send me any comments that you like. And on that issue or any other issue. If you have any comments about the Tesla, MMTLP and the arbiter and the arbitration and that kind of interesting meeting, or what I've kind of rambled on about GTII with the hearing on Wednesday for a receiver and or an injunction or a temporary restraining order, let me know. And again, I will report back sometime Wednesday to give you an update as to what happened at the hearing. If anything happens before Wednesday, if a party files another brief, which may happen, I will try to report on that also. And I will, as soon as I file my own stuff in my case, which again might be impacted by what goes on in Vegas, I will certainly let you know. I have a bunch of things in mind. I'm trying not to disclose them until I do it. I'd rather not give them a heads up. But I have a plan in my head, and as to the same matter involving these guys, GTII. Anyway, hope everybody is well. Be well. Stay cool if you're in a place that's not cool. If you're in a place that's raining or is expecting tropical storm, etc., be safe and sound. And that's about it. Have a great Sunday. Be well. And again, I'll update you again if I get additional information. And be well out there. Take care. Talk to you soon.